In the final presidential results, the National Resistance Movement candidate Yoweri Kaguta Museveni polled 7,946,772 votes, representing 71.65%. The closest challenger, Senator Robert of the National Unity Platform, came in the second position with 2,841,238 votes, with a percentage of 24.72%. After the announcement of the results, Robert Kasibante, who pressed sixth in the presidential race, filed a petition challenging President Museveni's victory. He claims irregularities in the electoral process, the involvement of security operatives, use of government resources, bribery, and vote rigging, among other grounds. The judiciary says it has put in place special measures to handle election petitions.
We have the human resource, we have done the trainings, we even continue, we shall have even more trainings as matters arise. So we are ready to go.
Robert Kasibante filed the petition against the Electoral Commission, President Yoweri Kaguta Museveni, and the Attorney General.
And I think I've seen it reported on social media and so on and so forth. But we as the Directorate of Legal Services and the NRM, particularly for the presidential candidates, it has to be served on the person whose result is being challenged. Well, I am not aware that he has been served, and at the moment we have not received any instructions.
The National Resistance Movement legal team says it will defend all petitions arising from the elections.
At all times, whether it is election period, whether it is not election period, we maintain generally a team of about 40 to 50 lawyers at all times. There are many matters that go on even without electoral litigation. So we are always prepared. We have sufficient human resource.
Legal experts have also outlined the laws governing election petitions.
Petition is supposed to be filed within no more than 15 days from the date of the declaration. Usually, once the parties have been served, they have 3 days to make a response.
That means that everybody has responded to whichever issues that have arisen. Then the constitutional reform comes in and the hearing takes on. What's very key is that from the time of filing, within 45 days, it should be done.
Timelines are usually very strict and very stringent. They are not subject to change because they are constitutional timelines. So I think that is the general framework.
Following the retirement of the former Chief Justice Alphonse Chigamoy Owunyidolo, questions have risen about how the Supreme Court will handle the presidential election petition.
And Article 131, Article 3, it says that the Chief Justice shall preside at each seat of the Supreme Court. In the absence of the Chief Justice, the most senior member of the court as constituted shall preside.
With strict constitutional timelines and backlog of cases in the courts, how will the electoral petitions be disposed of in time?
The law provides that when there are petitions of an election matter, these matters take precedence. They're very important. So they are handled as priority. Because you see, there are decisions which will affect the entire nation that need to be decided within prescribed period.
Lawyer Wandele Ogal looks at whether presidential election petitions would serve a meaningful purpose, given the past Supreme Court decisions.
Disputes should be resolved through the court system. Mistakes are made, and these electoral processes, like a presidential petition, help us to improve where things have gone wrong.
With the swearing-in of the president-elect approaching and in the absence of the Chief Justice, Judiciary has also clarified on who will conduct the ceremony.
That in such an event, those functions will be handled by the Chief Justice. It's within the Constitution. So there is no lacuna because we have the Deputy Chief Justice. And as you rightly recall, yesterday, the Honorable Chief Justice handed over to the acting Chief Justice. And that is within the confines of Article 1.
Deborah Namamonde, Robert Katamba, UBC News.